Hey, and thanks for tuning in to the Maryland Family Law Podcast, hosted by attorney Mike Mastracci of MikeTheLawyer.com. If you're looking for practical guidance navigating difficult transitions with clarity and experience, then the conversation starts right now.
Your Honor, thank you for that kind introduction. I greatly appreciate it. And now it is my distinct privilege to introduce Bradley Shepard. Bradley is, I'm going to sum it up, he's a kick-ass criminal law lawyer, amongst other things. Bradley has been a medical malpractice defense lawyer for a year, realized that was not something he wanted to do full-time. He also had his own practice, primarily criminal defense, for about a decade. And then within the last few years, he became managing partner of the criminal law division of a prestigious firm by the name of Posner and Cord, and they are also known as CharmCityDefense.com. And today, Brad and I are going to have just a discussion about the intersection of family law, protective orders, and criminal charges. And Brad, he gets involved in family law cases a lot of times from their inception by way of an emergency hearing, emergency protective orders, and things like that. And he is also smart enough to realize that he would like to get in from the beginning and get out, as opposed to the long drawn out family law case. But the beginning can be very treacherous and it's got to be handled correctly. And I have referred numerous cases to Brad over the years, and I can do that with the utmost confidence. So, Brad, thank you for joining us today. I appreciate it.
Hey, fun time to be here, Mike.
Absolutely. It's a little warm out, but we'll get through it. A lot of the cases I know you receive from lawyers referring to you, or I guess some on your own, deal with the immediate, we have a protective order case tomorrow at 1 p.m. Can you be there? And then you have a short opportunity to get the facts together and do what you can. So tell us a little bit about how those types of situations develop.
Yeah, sure. The protective order process and the peace order process in the state of Maryland is designed to be a rapid legal intervention to potentially volatile or dangerous situations. So if you have a domestic violence scenario or a child abuse scenario, or even just a neighbor dispute that's going to escalate to a physical confrontation, these processes allow rapid court intervention to take these two parties that are about to go at each other and separate them. So I will get calls from prospective clients or from lawyers who are referring a case to me. Sometimes I'll get a call at 11 o'clock at night, like, hey, I have a hearing tomorrow. What can we do about it? And because of the emergent nature of these hearings, you can be caught completely flat-footed by them as a litigant. And having a lawyer who can get themselves up to speed basically instantaneously and be ready to litigate. It's a relatively narrow issue, but ready to litigate an issue basically at the drop of a hat. That's how I get involved in these. How these situations can occur, like I said, you could have a husband and a wife who get into some sort of physical altercation, and one of them goes to the commissioner. Commissioners are not judges, they are not lawyers, they are oftentimes just people with criminal justice degrees who get their job working for the judiciary, and they are tasked by the Maryland legislature to review these petitions and issue what are called interim orders. They are not judges, so they can't issue even a temporary order. There's three parts to the protective order process. There's an interim phase, a temporary phase, and a final phase. But when you go to a commissioner, you get an interim order, which can be something to the effect of needs to leave the house, needs to leave the other individual alone, have no contact with them, stay away from their job, their place of business. If there are kids involved, there can be an award of temporary custody. And when you have kids involved, or even when you don't, this is essentially shit hitting the fan for the average individual, because even something as simple as you can't go back to your home where you sleep, where your belongings are, where your computer is, where your keys are. It's traumatizing, and it's a big problem very quickly. So that's how I can kind of get involved in these things, to try and make heads or tails of them and try and get them ready for the next phase of the process.
It's funny that you say that. One of the biggest complaints I hear when a protective order has been issued and the police come, and I'll call it male female, but it's not always a male female situation, obviously.
Sure.
But let's just say, for example, the police show up and say, okay, you've got to go. I got a court order here and you've got 10 minutes, pack what you can. And you've got literally 10 minutes to take what you can take, and that's it. And if the hearings do not go well for that gentleman, he may be a year without getting his belongings unless there's some kind of arrangement made between the parties through counsel or the court. But even in that situation, they're not overly generous. I'm sure you've seen it a million times where they'll get a court. Okay, you have Saturday between 12 and 12:30 p.m. Get your stuff and have a nice day. It's a tough situation. But then again, so is domestic violence and physical abuse and things like that. So it's a tough balancing act because I would imagine that being placed in that situation where you've got 10 minutes to get your stuff, if you're already angry and upset at your, we'll call it spouse for sake of argument, I would say things will probably escalate for a little bit before they get any better.
Yeah, it's like most of the system as a whole, it's not perfect. It's what we got. And like I said right from the outset, the intention is to provide rapid intervention to take a volatile situation, two people who are about to get dangerous with each other and separate them. And like I mentioned before, these commissioners are not judges. They haven't even heard both sides of the argument. All they've had is one person go to them, say, hey, so and so hit me. I want an order of protection. And this commissioner, without any additional facts, without any additional corroboration, does what the legislature instructs them to do, which is separate these two parties. But yeah, that can feel to the party who's getting ousted from their house incredibly unfair and manipulative. And while there are countless examples of this process being used for good, there are also just incredible number of instances that even that I can point to from my practice, and I know from other practitioners that this process is abused as well, because with no corroboration, no evidence, someone who is willing to just go down to this commissioner and lie and say, hit me when that didn't happen, that commissioner is still going to do what that legislature it told them to do and kick that person out of the house to separate these people.
But Brad, aren't those things done under oath? I was
Yeah,
waiting for that laugh.
and I've been a criminal defense attorney basically the entirety of my career, and the only person I've ever known charged with perjury is Marilyn Mosby.
That's a good point. Yeah, a lot of people say, "Oh yeah, he or she's perjured himself." Okay, who cares? It's sad. Doesn't matter.
I get lied to every single day. I don't take it personally. It offends me. You just can't take it personally because it literally happens every day. If I got upset every time someone lied to me on the stand or signed a document under oath that was perjured, I wouldn't make it through the day.
Let's talk for a minute about the different burdens of proof, because a lot of times, as the protective order petition, if you will, really forms the basis of an underlying assault, perhaps, or harassment, or some type of criminal offense. So the person who is filing the protective order always has the option of upping it one level and filing criminal charges along with it. But there are different burdens that apply, correct?
Yeah, so I guess I'll start with just the definitions of peace orders, protective orders, and then criminal charges, because peace and protective orders are civil in nature, whereas criminal charges are obviously criminal in nature. And a peace order would be what someone would get if they were having if they were being threatened or they were being abused or attacked or harassed by someone who is not a blood relative of theirs, someone that they have not been in a romantic or sexual relationship with, an individual that you might know, but you're not related to them. They're not a close, relationship like that. So if you and I, Mike, were to get into a fight, one of us could go get a peace order, right? And a peace order is different in that regard because you actually have to prove two things for a peace order. You have to prove that an act of abuse occurred, that some prohibited act has occurred, and also that there is a likelihood that it's going to happen again, which is different from a protective order, because of a protective order, you only have to prove that you are a person eligible for relief, which basically means that you are related by blood, marriage, or that you've had a sexual relationship with them within the past year. And once you prove that, the only other thing that you have to prove is that a prohibited act has occurred, right? So there's not that second element of, and it's likely to happen again for a protective order. And criminal charges obviously can be filed by anyone against anyone. And the processes for getting peace and protective orders and criminal charges is basically the same. Any civilian in the state of Maryland can go to the commissioner's station. We have them at literally every district courthouse in the state of Maryland. A lot of them are open 24/7. And you walk up, you say, hey, I want a peace order. I want a protective order. I want to file criminal charges. The person behind the glass will hand you some documentation. You write on it what you say happened. You sign a page saying that you swear under oath that is what in fact happened. And then the commissioner will issue it, right? So you asked about the stages. At the interim stage of a peace or protective order, the standard of proof is reasonable grounds. And also, what that basically means is that the commissioner will answer the following question, because they don't know if what you wrote is true or not, but they'll ask themselves the following question, metaphorically, essentially. If what this person just wrote down is true, would that entitle them to a peace or protective order? And almost always the answer is yes, because that's an incredibly low burden. So if you get an interim order, you get interim orders when court is not in session. So if you went after hours during the week, or if you went on the weekend, because like I said, these places are open 24/7, you get an interim order. If you go during business hours, though, when court is in session, you'll see the commissioner, you'll fill out the form, and then you'll be sent directly to the judge. This is the temporary stage. So if you go in during off business hours, you'll see a commissioner, you'll get an interim order, and then the next business day, you'll have the temporary order. If you go during business hours, you'll skip the interim, go directly to temporary, where the burden is still the exact same. It's that reasonable grounds, which again is a bare bones showing of or allegation of what has happened. And again, the judge will ask the same question. I have no idea if what this person just wrote is true, but if it was, would it entitle them to a peace or protective order? In that stage, the answer is almost certainly yes. Temporary orders will last typically for 1 week. By law, they must last for 1 week. But we who actually do this and handle these cases know that what is written down in the law by the legislature doesn't always translate to practice, because you can have a temporary order and it gets postponed or it gets moved or whatever happens. I've had a protective order. This was an egregious situation because it happened in the beginning portions of COVID, but I once had a temporary protective order last 6 months while we were waiting for a final hearing because the courts were still trying to figure out what to do with all the COVID stuff in the middle of 2020. That's the exception, not the rule, because most of these do happen in 1 week. And then the following week, you have a final protective order, final peace order hearing, where the burden does rise significantly. And the person seeking the order, the petitioner, has to prove by what's called a preponderance of evidence that the peace or protective order should be granted, which again, for a peace order means that a prohibited act occurred and it's likely to happen again. And for a protective order means that you're a person eligible for relief, meaning related by blood marriage or had a sexual relationship within the past year, and an act of abuse has occurred. And they bear that burden. So preponderance of evidence means more likely than not. So if you picture the scales of justice and you put one feather on one hand and the scales tip just a little bit, 50.0001% is more likely than not that will win the day. But what you hear a lot in these hearings is, because just of the nature of the allegations, a lot of this stuff happens behind closed doors, where the only two people who would know what happened are the two people who are involved, the petitioner seeking the order and the respondent, the person defending against the order. So a lot of times you see the petitioner stand up and say, this is what happened to me. He hit me, or they pushed me, or whatever it is. And the other person stands up and says, unequivocally, that didn't happen. They're lying. And judges, this is why they make the big bucks, are placed in a really tough position there, because credibility is what rules the day in these cases. But oftentimes I'll hear judges say something to the effect of, sir, I heard you testify saying that she hit you, and I believe you. I have no reason not to believe you. And ma'am, I heard you when you testified that absolutely didn't happen, and I believe you. I have no reason not to believe you. And because I believe both of these stories equally, we are at equipoise. We are equal, right? Each story is as likely to have occurred as the other, and that is not enough. I've won cases dozens and dozens of times on that argument, is that the story is just as likely to have gone down the way that they said it versus this other person said it, and that is not more likely than not. So how does that tie into criminal defense and criminal charges? Because all of these examples that I'm giving, like he hit me, she pushed me, they attacked me, these are all in the peace and protective order context civil in nature because it's a peace and protective order. But the allegations themselves are of crimes, of criminal conduct, right? Hitting someone is against the law. It's an assault, unless it's justified, but we're not talking about that. So just as easily and at the exact same time as someone gets a peace or protective order by going to the commissioner, they can fill out criminal charges, swear out criminal charges against that same person. And again, that commissioner doesn't really do much of a fact checking. They just mostly issue the charges, assuming that the allegations would merit charges if they were true. And this is where you really disconnect from the civil nature of the matter, because no matter how burdensome and how inconvenient the consequences of a peace and protective order may be, your liberty is not at stake. You will never be jailed at a peace or protective order hearing for whatever may or may not have happened to bring that into court. However, the second that criminal charges are filed, now your freedom is at stake, because a second-degree assault in the state of Maryland carries a maximum penalty of 10 years and or a $2,500 fine. So the stakes get incredibly ratcheted up in that regard if criminal charges are filed. And that could be second-degree assault, malicious destruction of property, trespassing, harassment. I see telephone misuse a lot, revenge porn. These are the types of things that I see, particularly with intimate partner violence and then the fallout of criminal charges. And the thing that I always say to people all the time, it is one thing for there to be enough evidence to be charged with a crime, and it is quite another thing altogether for there to be enough evidence to be convicted of that crime. Because the burden of proof in a criminal case is obviously beyond a reasonable doubt, which we don't have a percentage to it, but it's way higher than preponderance of the evidence, which is just over 50%. So that's kind of how all of these things play into each other.
One issue I want to address is when you are preparing with your client whether or not to contest a protective order or consent to it, there's some significant ramifications for doing one or the other. And I guess I'll let you address that since you're the guest.
I hadn't mentioned that yet, but that's a fantastic point. Anyone who is the respondent, the person facing a protective order, not the person seeking it, you have an unequivocal right to consent to a protective order without there being a finding of abuse and without you admitting that you have done anything wrong. So what does that mean? It means that you can consent to the relief that's being requested, agree to stay away from the person seeking the protective order, most likely to leave the home, to stay away from the home, to have no contact with them, to stay away from their place of business. And if you do that, there's a couple things, and there's a few reasons why people choose to do that. Number one is if there is no realistic hope of prevailing on in the case, right? If the allegation is they punched me in the face and here's the picture of the black eye, or actually even better, here's a video of it happening, because everyone's got Ring cameras and Blink cameras, and there's so much personal in-home and exterior home surveillance these days. A lot of this stuff gets captured on surveillance. If there's a situation where the evidence that this person is going to be able to present to prove that you did in fact commit this act of abuse, you should just consent to it. Because if you consent, as I mentioned, you still get the petitioner, the person seeking it, still gets all of the relief that they're seeking, but you, the respondent, have not admitted that you've done anything wrong, and the court has not found that you've done anything wrong. And the reason why they can do that is because, as I mentioned before, these matters are civil in nature. And when there are civil matters, the court doesn't really get into much into who's in the right and who's in the wrong. If the parties can agree on an outcome, by and large, the court in any civil matter is just going to rubber stamp that outcome. If you can come to an agreement with someone, court's just going to rubber stamp it. And the other reason we might agree to a consent is, there's a few other reasons, but if there are criminal charges, so someone filed a protective order at the same time that they filed criminal charges, my personal belief is that you should be prioritizing the criminal charge. Because, as I mentioned before, no matter how inconvenient or frustrating the consequences of a piece of protective order are, you're not going to jail over it. But you could go to jail if you're found guilty of a crime. And the reason why you often consent in that scenario is because, as any television legal drama will tell you, you have the right to remain silent, and anything that you say or do can and will be used against you in a court of law. Now, those are your Miranda rights, or portions of them, that typically are read to you when you are arrested or when you're about to undergo what's called a custodial interrogation. But so you're not read those rights in court, but you do have a right to remain silent. If you are charged with a crime, or even if you're not charged with a crime, but possibly by testifying, you could implicate yourself, you have an unequivocal Fifth Amendment right to remain silent, because what you say in the piece of protective order hearing, the prosecutors can get that recording and they can use it against you. So if you say something wrong, or if you say something that you misspoke or you misremembered, and then you try to get into your criminal case and you try to correct that error, the prosecutor will hammer you for that mistake. And again, you don't want to put yourself into a scenario where your criminal case could suffer because of something that you said in the civil case. And the last thing that I'll say is about records. So if you have a peace or protective order that you contest and you go to a trial and you lose, that peace and protective order will stay on your record forever. There is no opportunity for you to shield it, meaning remove it from public inspection. If someone types your name into the case search, that case will pop up and that will be there forever. If you consent to the entry of a peace or protective order, again, you've not admitted to have done anything wrong, the court has not found that you've done anything wrong, and assuming that you navigate the duration of that peace or protective order without violation, and you don't get convicted of any related criminal charge stemming from that, you have the right to have that peace or protective order removed from public record once the order concludes. So I see people oftentimes say to me, Brad, I don't care about the protective order, but I don't like that when I case search my name, it says domestic violence, because that's what these are listed as, right? Protective orders are listed as domestic violence on the Maryland Judiciary case search. And by consenting, you leave yourself the opportunity to remove that from public inspection. If you take it to trial, like any trial, you're taking on a risk reward analysis, which is, if we win, great, we'll go home and celebrate. But if we lose, we could suffer this consequence.
Speaking of consequences, you and I and judges know what no contact means. And for some reason, people who have a protective order against them or criminal charges where it says no contact seem to not get it, that contact, any sort of contact is contact. A phone call, a text message, telling your neighbor to relay a message. It amazes me how many people cannot get that straight, that no contact means no contact. And that to me is one of the easiest ways to land in jail. If there's a protective order in effect and a person says he or she violated the protective order by contacting me, they scoop you up and ask questions later. And you're typically in jail with no bail for a little bit.
Yeah, the reason you're in jail with no bail for a bit is because the commissioners, when you're arrested in the state of Maryland, you're taken before a commissioner, typically within 24 hours. The Constitution says within 24 hours, but certain places in the city that might not always happen. Most of the state of Maryland, it happens within a handful of hours, 2, 3, 4 hours, something like that. So you're arrested, you're taken before a commissioner. And the commissioner is the first person that you see who has the ability to release you on your own recognizance or set a bail amount so that you can go home. But the commissioners, in certain scenarios, there's really only a handful of scenarios that they have literally no jurisdiction. They have no authority to release people. And one of those situations where they have no authority to release someone is if you are charged with violating a protective order. Because violating a protective order is inherently an allegation that you are violating a court order, right? A judge has issued an order. And a lot of judges are really cool, really nice. They're polite, they're collegial, they treat people with respect in all of their dealings. But you want to piss literally any judge off basically instantaneously, ignore a court order. Just blatantly ignore a court order. They go from 0 to 100 immediately.
that goes back to, I don't know about you, but lessons from childhood. When my mother would say, don't don't do this, don't do that. I said, why not? Because I told you. And it comes back to the I told you. I'm a judge and I told you and you violated it, so you're in trouble.
Some
I digress, but you know what I'm
sometimes
saying.
it is that simple, right? You and I are pretty knowledgeable on these topics and we do this every day, but at the end of the day, in a courtroom, there's only one person wearing robes. There's only one person paid to make these decisions, and it's not me. Yeah, violations of protective order. So I'll have to amend something that I said earlier because what I said was a protective order or peace order is not going to land you in jail, which is true. But as you said, and almost with near 100% certainty, you will be arrested if you are accused of violating a protective order. So, what does that look like? You mentioned no contact. No contact is, I agree, the biggest way that people violate protective orders because one of the main provisions of any peace and protective order, because the whole purpose is to separate you two, right? Is to get you guys who are about to butt heads away from each other. So, the main provision of a peace and protective order is stay away, have no contact. Now, Maryland doesn't do the thing that you see a lot in bad court dramas and legal dramas where you must stay 500 feet away or 100 feet away or anything like that because if they take a step towards me, what am I supposed to do? A dance with them where I move backwards and forward as they move backwards and forwards to maintain 100 feet away? No, that's weird. It's odd to enforce. No one walks around with a ruler, so how are we going to measure that? Maryland is more of a common sense interpretation of stay away, have no contact. If you are ordered to stay away from a residence, that's pretty obvious. Don't go near that home. But there are public spaces that the courts are not going to be able to order you in a peace of protective order to avoid. The example that I always give is a supermarket, right? You turn down an aisle in a supermarket and you see the person that you're supposed to stay away from. Technically speaking, you can walk right down that aisle as they walk right past you and not violate a protective order. But that is a horrible idea. It doesn't work in practice because what inevitably happens is the other person is going to get freaked out. They're going to say, oh, they looked at me, they menaced at me, they growled at me, they flipped me the bird, they called me a bitch as they walked past me, whatever it might be. And now you are violating it. Even if you didn't, they said you did. And like I said before, the commissioners will issue these warrants and these orders and let the judges figure it out later. You might think you're slick going right up to the edge of the order, but not crossing the line. But you're not going to be slick when you're arrested waiting 12 hours to be released.
Brad, do you remember? It's been a long time ago. I'll date myself, but a lot of these protective order cases where the judge became hypersensitive, it got so bad for a while years ago that basically a woman, again, I don't mean to use man, woman, but just that's the way the majority of them shake out. It's not a sexist comment, it is what it is. But a woman could say, he sneezed at me and I could tell he did it on purpose. Protective order granted. They would really grant them over absolutely nothing a lot of times. Where that came from years ago in practice, I think it was Prince George's County, where a lady was alleging all of her fears and concerns. And the judge said something like, I hear what you're saying, but there's really no objective findings, and I'm denying your motion for your grant of a protective order. And that night, she answered the door, and the husband doused her with gasoline and lit her on fire. I don't think she died, but she was burnt unmercifully if she didn't die. And after that, there was a distinct change that lasted, I think, to this day about the judges are going to err on the side of caution. So a little push is a push, a threat is a threat. Whereas before they may have been brushed aside as quote unquote no big deal. Everything is a big deal, and there's reasons for that, and it should be to some extent, but it just means that you've got to, if you were one who was likely to commit an act that could be perceived as violence or threat or intimidation, you better tread lightly is the bottom line.
Yeah, the point you're getting at is make sure that you are strictly, vigilantly abiding by court orders because if you even are accused of coming astray of them, there will be consequences, even if those consequences are temporary, right? We might get into court and beat the allegation in the criminal case, but that's not going to help you when it's Tuesday morning and you can't go to work because you're in jail, right? Because you got locked up over this. And this was before my time, but I do know what you're talking about. because right around the time that I became a lawyer is when the law changed. So I imagine that this was right in that early 2010s era that you're referring to, because right when I became a lawyer, the standard of proof for protective orders and peace orders was still clear and convincing evidence.
Correct.
And it changed around the time that story happened. I'm pretty sure that story was
Yes, you will. You're exactly right on your time frame too.
And for those listening, clear and convincing evidence is not quite as high as beyond a reasonable doubt, but it's higher than preponderance, right? So it's a little bit more than 50, not quite 90 and above or whatever beyond a reasonable doubt is. And around the time that incident happened that Mike was just mentioning, the legislature had a big push and they lowered the standard, because again, the purpose of these civil cases, these civil peace and protective orders, is for rapid intervention to separate people in a volatile situation. While it's easy sometimes in my position to cherry pick on the people who bend the rules and manipulate it to their advantage, because someone who's about to get a divorce knows that if they go and get a protective order, they can get the home, sort of thing. What we say in the profession is that they're using the protective order process as a sword, not a shield, right? So they're using it as an offensive weapon, not as a defensive mechanism. But as much as that happens, by and large, the protective order process has saved people, has protected people, has made Marylanders safer.
Good point. Excellent point. I guess before we close, why don't you be so kind as to give everybody all of your contact information?
Oh, sure. Yeah. So if you're looking for me online, it's charmcitydefense.com. My office is in Timonium, and if you're ever looking to get a hold of me, the office number is 410-252-0600. But I've never been shy about my cell phone number. I kind of think that one of the main jobs of a lawyer is to answer the phone. So if you ever need anything, call me, 443-765-4489. That's my personal cell phone number. That's not a gimmick. That's just how people in touch with me.
Knowing the law and knowing what the judges are likely to do and how to advise people, but being responsive is a very key thing. If I'm a client and I need to talk to a lawyer, even if I really don't need it right this second, if I think I do and I can talk to that lawyer, it means the world to a potential client. So, Brad, I want to commend you on that. You do a really good job at that, bud.
I appreciate it. Yeah, the people who ended up need me, I'm not the fun lawyer to need. You don't want to need to call me. But when you don't get to choose when you need me, that can be 3 a.m, that can be 6 a.m., that can be what the realities of life don't wait for a convenient time for you to need a criminal defense lawyer. I recognize that my clients are oftentimes going through something really traumatic, really scary. And obviously, I'm a family guy. I have a family. I do sleep. But if I'm up and I'm not doing anything, of course I'm answering the phone. And if it's something emergent, of course I'm getting back to people, because that's the job.
That's it. I think it's a good note to land off, to move forward on, or to say goodbye. But Brad, thank you very much for your expertise. Always a pleasure talking to you, and we'll have to do it again soon. All right.
Yes, sir. Talk to you
Take
later,
care,
buddy.
boss. Bye.
Well, it looks like it's time for us to tune back out. Until next time, stay well and keep in touch with MikeTheLawyer.com.